Hey there, welcome to Work Comp Talk, a podcast where we educate injured workers all over Northern California. My name is Carmen, your host, and joining me as always, my co-host, Bilal and Carmen, managing attorney at Pacific Workers, the Lawyers for Injured Workers, which also happens to be our sponsors for the podcast. If you haven't yet subscribed to our channel, make sure you do so now. There's a ton of tips and information we constantly share throughout this platform. We hope you get to enjoy another episode where we're going to be diving into frequently asked questions, and those questions come through comments on our social media and particularly YouTube as well. So you ready to answer some questions?
I am. Let's do it.
All right, we're gonna dive right in. So question number one, and these questions are all again coming in from social media accounts. So if you haven't yet followed us on social media, this would also be the time for you to check out where you can bump into us, whether that's TikTok, Facebook, Twitter, Google My Business, Yelp. I mean, we are everywhere. So here's the first one. What do you do when the problem seems to be your attorney in your workers' comp case or the assistant attorney?
So that depends. I would say, really evaluate whether or not the attorney is the problem, or it's the system or the doctor or the adjuster or something else. Oftentimes in workers' comp, we have limited resources available to us as attorneys to troubleshoot issues that come up. And so oftentimes it may seem like maybe you're working against your attorney when in fact your attorney is working with you. It's just not going your way because there's roadblocks in the way. And so I think really taking the time to understand what's going on in your case and talking to your attorney to understanding whether or not it really is an issue on their end or if it's an issue with the system or something else. And so, I always encourage people, don't just jump ship on your lawyer, and we don't want to necessarily steal cases from other firms. And, so we'll tell people, hey, if you have an issue with your lawyer, try and work it out with them first before coming to us.
Yeah.
And same thing, if you had an issue and it was with our firm in particular, I would tell you, hey, let's talk about it before, you make any real decisions to see whether or not it really is, us or your other lawyer or someone else is the problem. And so I'd say create a dialogue, if you find out that, let's just say your attorney is completely incompetent and, they've told you, hey, I'm doing something and it's been 18 months and they haven't done it yet, and you've had multiple discussions about it and it's clearly the attorney that's a problem, you can always terminate your attorney. You can fill out what's called a dismissal of attorney form and a substitution of attorney form, and you can hire a new attorney.
And you don't have to pay out of pocket to that attorney that helped in the first case just because you're dismissing him. That will get handled at the end of the case, if I'm not mistaken.
Yeah, so you sign a contract with your attorney to pay them a percentage. It's a contingency fee agreement. If you terminate that attorney and hire someone else, then generally what happens is the attorneys will fight over that fee. And so, the second attorney will say, oh, well, first attorney, you were crap. You didn't do anything, so I'm taking the majority of it. The first attorney will say, hey, I did all this work, which was the foundation of your success in resolving the case, so I want my share too. And they call it, the Latin term is quantum merit. It means, basically what you've earned is
from
what you're entitled to. Exactly.
Interesting. Well, that's good to know. And as you've mentioned, just have a conversation, an honest conversation with your attorney and tell them how you're feeling, because sometimes I think most of the time we've noticed too, even with clients that we've had in the firm, they believe that the attorney is against them, when in fact it's just the way the system works, the amount of time it takes to get things approved, the games that the insurance company plays to kind of just get you tired of the system and hope that you end up just quitting your case altogether and they can save themselves some money.
Mm-hmm.
But ultimately, having a conversation with the attorney could definitely help.
Yeah, and definitely. I mean, our job as attorneys is to deliver not only good news, but bad news too. And there's some times where my clients have told me, hey, Bilal, feels like I'm arguing with you. And we are arguing with you. You're my client, but I'm trying to explain to you my recommendations as your counsel what I think is in your best interest. And maybe we're not meeting and maybe you don't understand. I'm trying my best to articulate that so that you do understand. But there may be sometimes where clients want to do things that aren't achievable or going against their attorney's recommendations. And that's, it's not a bad thing per se. I think it's good to have spirited discussions and understand where we're coming from. I think it starts to become a problem only when the client is adamant about going in a direction or the attorney is adamant about going in a direction that doesn't jive with what the client wants. And at that point, maybe there's a conflict of interest so substantial that maybe it isn't a good idea to continue on with that particular lawyer and client relationship.
Gotcha.
But again, sometimes the system is just really crappy. An example may be someone who isn't getting paid their benefits, and the insurance company won't pay them, and so we have to drag them to court. Sometimes it can be upwards of a month before we get a court date, and in that time, the client may have rent to pay, may have bills, may have things going on, and they feel frustrated and feel like the firm's not working for them, when in fact that's just a situation where it's just what the system is.
Yeah, it's a really difficult situation to be in, of course, as an injured worker, because you're trying to make your ends meet. And sometimes the only person you can get a hold of is your attorney, and not necessarily anybody from the insurance side. Mm-hmm. So it's easier to just go off on your attorney than, to get some of that frustration off. But at the end of the day, any attorney that you're working with, their goal is the more money you get from your settlement, the more money the attorney gets. And there's also been a very misconception that attorneys work with law firms, work with the insurance companies, and they work against the injured worker because they take more money. That's not how it works.
Yeah, no, there's been situations in the past where, in weird ways, insurance companies have tried to entice lawyers to take less money on a settlement. One of those is what they call 5710 fees. So we're paid in deposition to represent our clients, and there's been cases where attorneys for the insurance company, have offered to essentially overpay an attorney for their deposition fees in order to entice them into recommending a more immediate settlement to their client.
Interesting.
So that's not something that's happened to anyone that I know of, but I've heard of stories of that happening in Los Angeles and elsewhere. So there are times where, insurance companies and their attorneys have done shady stuff trying to get cases settled, but just generally, we have an ethical and legal obligation to represent our clients' interests and nothing else. And so I've never heard of an attorney representing an injured worker doing anything immoral or illegal that would jeopardize the value of their case or their health.
Well, that's a good thing that you haven't heard any or know anybody of that situation around us. How long can I get TPD benefits for?
So TPD refers to temporary partial disability. Temporary partial disability means that you have functional limitations, but you're not entirely precluded from working. That could be a limitation regarding the number of hours you work, or limitations on the type of job duties that you're doing, but you still have some capacity to work, so the doctor doesn't want you just sitting around. So temporary partial disability counts towards the same cap as temporary total disability. Essentially, you can only get temporary disability as a whole, regardless of whether it's partial or full, for up to 2 years. So that 2 years does not have to be continuous. It can be broken up as long as it does not exceed a 5-year period. So you could have broken periods of temporary partial disability, throughout 5 years following your date of injury, or you could have it consecutively for up to 2 years total within that 5-year period.
Okay.
Once you hit that cap, that's it. No more. There's certain injuries that are exceptions to that, up to 240 weeks. And those are injuries like high velocity eye injuries, HIV, things like that are amputations, just naturally injuries that are so substantial they take longer to heal.
Right. I would think so. What happens when after the 104 weeks are up in your workers' comp payments? Do you then apply for state disability? And it kind of goes hand in hand with the question we did previously a little bit.
Yeah, so there are a lot of injuries that aren't those exception injuries where you can get temporary disability up to 240 weeks, and a lot of people are still recovering. Maybe they have a situation where it's taken them a long time to get conservative care, and finally, at 100 weeks, now they're getting recommendations for surgery approved.
Mm-hmm.
And they can be in a bit of a pickle because now they don't have temporary disability.
Yeah.
If you were a W-2 employee, you've paid into state disability. It's a line item deduction on your pay stub. So if you check out your pay stub, you'll see it there. It says CA-SDI. And that's basically your own little savings account with the state. And the idea is SDI is there to pay for non-industrial conditions, or to the extent that you're off of work and you don't have any benefits from any other source, you can actually draw from state disability. So if someone were to exhaust their temporary disability, they could apply for state disability and receive that usually up to a year following whenever they exhaust their temporary disability. Of course, state disability does pay at a lower rate.
Of course.
And if you are receiving permanent disability advances, state disability will pay what's called differential, which is the difference between what you're receiving in permanent disability advances and what their rate would be if you weren't receiving anything.
Okay. Makes sense. How many checks do you get with the CNR?
Sometimes it's 2, sometimes it's 1. It depends. Sometimes what happens is the insurance company has little buckets of money allocated for certain things within their own internal accounting. And so they may send you a check that accounts for the permanent disability and another that accounts for everything else.
For the future medical and stuff like that?
Most of the time people just get 1 check.
Okay, so for those of you that are new to the workers' comp world and don't understand the term CNR, that is a compromise and release type of settlement. That's the type of settlement you would take if you no longer want to be treated within the workers' comp system. So they're kind of like paying you for your future medical benefits and anything that should be owed that they feel is a good amount for whatever injury you've suffered.
Yep. And either way, they have 30 days to pay you once it's approved. So, if you just settled your case via compromise and release and you got a check and it doesn't necessarily represent the whole amount, maybe it's like half or something, at least wait till 30 days from the date the judge approved the settlement to call your lawyer and, let them know. And at that point, it's potentially a problem if you haven't.
So let me ask you this. How often do these injured workers receive the check on day number 29?
Actually, I would say more often than not, it's quick.
Yeah.
Decade ago when I used to be a defense attorney, my insurance clients actually had rules that were in our contracts for, our representation for them, that any settlement instructions had to be transmitted to them within 24 hours to issue payment. So a lot of times they want to issue payment quickly because there's substantial penalties if they're late, even one day. And so I think more often than not, presuming that the insurance company actually gets notice that the settlement's been approved and they have an obligation to pay, usually they pay within like 2 weeks. They're usually quick because they only have 30 days by law to pay you. And most of the time they don't want to risk being in a penalty situation.
I would hope not. So here's another question, and this is in regards to when you have a workers' comp case, and it also ties in with a third-party case, personal injury. And these would, I'm assuming, would be the type of cases where you're involved in a vehicle accident while you're in a work route or something, or in a work vehicle. And this person wants to know if you can prove that your employer was 100% responsible along with a third party, can you receive both settlements at 100%? The third party settlement and your workers' comp settlement?
Maybe.
Frankie, you got a choice.
So here's how you do it. Workers' comp was designed as a carve out to personal injury. The idea is that you shouldn't be able to sue your employer for innocent injuries, right?
Right.
And a tragic accident happened, someone got hurt, it's no one's fault, it's just an accident, an act of God or whatever, right? And so the idea is that if you could sue your employer every time you got hurt, employers would all be bankrupt, right?
Literally.
Because there's accidents that happen all the time in fields like construction, the trade's just generally law enforcement, firefighters. And so it was designed as a carve out to kind of limit the exposure employers have, which is why it's also insurable. There's also the accidents that happen where, let's be real, the employer really effed up, right? They really did something that was terrible and they actually caused the injury. So if that happens, the credit that the employer gets against a third party settlement is reduced by their percentage fault. So if your employer really is 100% at fault for what happened to you and it was extreme negligence, you would essentially go and fight over the credit. So like if you received, a $100,000 personal injury settlement for the same accident and your employer was 100% at fault, you would argue that the employer's ability to take a credit for what you received in the third party case should be reduced to zero because it was 100% their fault. More often than not, when there is employer fault involved, it's usually negotiated down and it usually is some percentage of it. It's not, I've never come across a case where the credit was reduced to zero, except for technical reasons, meaning if the employer didn't file what they needed to and they waived their right to credit and things like that. But if there's employer fault involved, you can negotiate down the credit. And same thing, depending upon whether or not there's serious and willful misconduct, which is the employer doing something really bad, that can actually increase the value of your workers' comp case in addition to potentially what you would get otherwise.
You got options.
Yeah, if there's no employer fault involved, though, and the insurance company files, an intervener in your civil case and they file a petition for credit in your work comp case, there's a good chance that you're not getting away from that credit. And you're either going to have to deal with the lien for the work comp payments in the civil case, or you're going to have to deal with the credit from the civil case in the work comp case, which means most cases you can't double dip and get 100% of both, unless, of course, there's some fault issues and other stuff.
Interesting. All right, so this next one is actually, we have a couple of videos within our YouTube channel that kind of explain how to fill certain mileage forms, how to sign documents, etc. And this is in particular to one of the videos that we have in regards to logging your mileage for mileage reimbursements. And people want to know, these mileage forms are set for you to kind of go from your home to the doctor's office. How do you then calculate when you need to go from your house to the doctor, from the doctor to your job, or from your job? Like, how does that work?
You do your round trip mileage to wherever you started and wherever you're ending, right? So if you are going from, home to your doctor's office, but then you have special errands or things that you need to run personally, you do not get paid to run your errands, right? So like, if you were to go to from home to your doctor's office, then you wanted to go to the grocery store, then you wanted to go to wherever, you would just do your round trip mileage from your home to the doctor's office and back home.
Gotcha.
You wouldn't include all of your gallivanting around, but we would say use Google Maps or use Apple Maps and look up the mileage and use that to calculate what you're entitled to.
Interesting. Okay, so here's the last one. If I opt out to close our future medical with the workers' comp, does that settlement count towards subrogation against my third-party personal injury suit?
Yes. So any settlement...
Explain.
Yeah, any settlement you get in workers' comp is a potential lien issue against the third party. So whenever there's a third party that's negligent for your injury, whether it's a simple negligence case in an automotive accident, or it's a products liability case for defective manufacturing or safety issues, the work comp carrier is going to want their money back for what they paid for injury. Because their thing is like, look, dude, we didn't cause this. It was this person or company over here that messed up and caused your injury. We want our money back.
Right.
And so they'll file an intervener in your civil case to get their money back. And so if you receive a settlement in workers' comp, whatever they're paying you is just adding to the tab, basically, that they want their money back. I guess in some situations you can negotiate it down. Some situations, again, if they don't procedurally do things correctly, you can kind of knock that down as well. But generally speaking, they always want their money back.
Of course.
And they will. You have to disclose. You're supposed to disclose that you have a third-party case pending to the workers' comp carrier. You can't hide it.
Right.
And so, provided they've been given proper notice and they do what they're supposed to, you're going to have to deal with that.
Right. It's kind of like that rule where you can't double dip. You can't get your workers' comp and some as well.
Yep.
So that actually sums up all of the questions we have on today's FAQ session. We hope you guys got to learn a lot. And if there's anything else you'd like for us to dive into for our future frequently asked question episodes, please feel free to send us a comment on YouTube. And sometimes we may not be recording them, but we are answering them as fast as we can. We get bombarded.
Just harass us. And honestly, I love answering these questions. This is my life existence for the past decade or more. It's what I do. It's what I live for. And so I really enjoy being able to share my knowledge and help people, regardless of your clients of the firm or you're just seeing our stuff online and don't want us to help you, but you just want to educate yourself. We're happy to do whatever we can to do that for you. So
exactly.
Keep them coming.
Awesome. Thank you guys, and we'll join you guys hopefully soon in another new episode.